You know how in every single courtroom drama, it all comes down to one critical question. Who has to prove their story? Well, that's not just for TV. It's the engine of the entire legal system, a concept called the burden of proof. And today, we're going to pull back the curtain and see how it really works. Okay, so here's what we're going to cover. We'll kick things off with that basic question, but then we're going to uncover something really important. There are actually two different kinds of burdens. We'll break down each one, and then we'll tie it all together to see how the whole system is really about fairness and justice. All right, part one. Let's get right to it. Who has to do the proving? It sounds like such a simple question, doesn't it? But the answer to this is everything. It decides who starts on offense and who starts on defense in any legal fight. And you better believe the law has a very specific way of figuring it out. Okay, so the official textbook term is the burden of proof. It's the legal duty to convince the court you're right. But here's the twist, the thing most people miss. This isn't one single simple thing. So listen up, because this is probably the most important thing to get from this whole explainer. We don't really talk about the burden of proof. We're actually telling a story of two totally separate burdens. And right here, this is where all the confusion usually starts. To really get how a trial works, you've got to split the idea of proof into two different jobs. Let's take a look at what they are. So on one side, you've got what's called the evidential burden. The best way to think about this is just getting your foot in the door. You just need to show enough evidence to make a judge say, okay, this is a real issue worth talking about. But then on the other side, you've got the legal burden. And that's the big one. That's the ultimate job of persuading the court and actually winning the case. So let's zoom in on that first type, the evidential burden. How does a court even decide who has to be the one to bring something up in the first place? Well, courts often use this clever little thought experiment. It's called Taylor's test. You just asked two questions. First, if nobody said anything or showed any evidence on this point, who would lose? And second, if we just deleted this allegation from the court file, who would lose? Whichever side fails that test, that's the one who has to get their foot in the door. You see this play out all the time in criminal law. Now, the prosecution always has the ultimate legal burden to prove guilt. But if the person on trial wants to claim something specific, like self-defense, or that they were forced into it, or they have an alibi, it's on them to raise the issue. They have to produce at least some believable evidence to make it a live issue for the jury to even think about. And the bar for this isn't nothing. As one judge brilliantly put it, you can't just have a facile mouthing of some easy phrase of excuse. In other words, you can't just mumble self-defense and call it a day. A judge has to look at what you've got and decide if there's enough real substance there to even put the question to a jury. Okay, let's move on to the main event, the legal burden. This isn't just about starting a conversation. This is about who has the massive responsibility of winning it. The starting point here is actually really intuitive. It's basically, he who asserts must prove. If you're the one making the accusation or filing the lawsuit, it's on you. You're the one asking the court to do something, so you have to convince them that you're right. As a judge explained, this burden is on the plaintiff for every single essential element of their case. Think of these like the load-bearing walls of a house. If they can't prove even one of them, the whole structure of their case comes crashing down. Okay, now this is where things can feel a little backwards. It's easy to think you only have to prove that something did happen. I mean, how on earth can you be expected to prove that something didn't happen? But the law is absolutely totally clear on this. And here's the rule. If proving a negative, proving something did not happen, is a core, essential part of your case, then sorry, that burden is still on you. Just because it's hard doesn't mean you get a free pass. And this isn't some obscure legal corner case. It happens constantly. For a rape conviction, the prosecution has to prove an absence of consent. In some contract disputes, you might have to prove the other side did not do what they promised. Proving a negative is a really common and really critical part of winning a case. So you have to be asking, why? Why are all these rules set up this way? To really get it, let's connect all these ideas to a real-world case that was all about fairness. So let's look at this incredible case about a chartered ship. The whole thing was just obliterated by a massive explosion, and that set off a huge legal fight over whose fault it was. So here's the play-by-play. A company hires a ship from its owners. Then, disaster strikes. A huge explosion destroys it. The contract is basically wiped out. But the million-dollar question was still hanging in the air. Did the owner's negligence cause the explosion?
No one really knew. The evidence just wasn't there. And this is where it all came to a head. The company that hired the ship, the plaintiff, argued that the owners should have to prove they weren't at fault. Sounds reasonable, right? But the highest court in the land disagreed. They ruled that since the charterers were the ones bringing the lawsuit, it was on them to prove the owners were at fault. And since they couldn't, their case just evaporated.
So why did the court decide it that way? They looked at a few things. They considered past cases, and they definitely thought about how hard it is to prove a negative. But as you can see, what really drove the decision was something much broader. At the end of the day, the thing that tipped the scales was what the court called general considerations of public policy. They were basically asking what rule is the most fair, the most sensible, the most just for society as a whole. It shows us that these rules aren't just some rigid, unthinking formula. They're a tool the law uses to get to a good outcome. And that leaves us with a really fascinating final thought. The burden of proof isn't just some dry, technical rule. It's this living, breathing tool that the law uses, shaped by history, logic, and these big ideas of fairness, to decide who has to carry the weight of an argument. Which makes you wonder, if the rules of proof themselves are flexible, what does that tell us about what fairness truly means to the law?